Dear friends, we are going to deliberate the judgment of the Honorable Supreme Court in this case, State of Maharashtra and others. That is, Prithish is the appellant before the Supreme Court. And this is a landmark judgment delivered in 2001. The main issue is when there is a complaint under Section 340, which envisages that whenever somebody misusing the judicial process by making false statements, suppressing the material evidence, fabricating the material evidence, etc. So, how this case developed? It is basically the court decided what is the ratio, what is the law decided in this judgment is that suppose a person makes false statement and then derives a benefit. In this particular case, I will go in before I read out paragraph by paragraph. The person, Land Acquisition Act, the first level, they have ordered 24,000 per acre compensation. And thereafter, all of them fought and then got 10 lakhs per acre. It was raised substantially. So, fine. To that extent, it is fine. Then later, it came to the notice of the others, not the people who were benefited, including somebody benefited. These other the benefited people, they found other persons who also got benefited. They have filed forged documents and then manipulated the information, filed false statements. And they filed as per Section 340 to the court, which has granted them based on the evidence they have submitted. Fine. That part is there. The referral court, that is the court, has gone through everything and felt that there is a case made out and then ordered. They have done a preliminary, this is a civil case, no, land reforms compensation, directed the jurisdictional high court, jurisdictional court to look into this matter and proceed with the, so that means the prosecution will be done by the state. It is not like a private complaint. It's a private complaint, but it's a complaint by the court. And then the magistrate will have to follow 238 to 40 of the code, wherein he will have to go through independently. It is not just taking the whatever the referral court has said, take it in and then start the thing. Normally it will be done. If High Court comes to a decision that there is a offense made out under 191 or 193, etc., punishment. So the persons aggrieved immediately approach the High Court and then Supreme Court. What is their grievance? Their grievance is the principles of natural justice has not been complied with. When you are going to decide a case against, they have decided against us that we have committed some errors. Therefore, we should be heard. Then that is the case. Whether the principles of natural justice should be complied with or not. Non-compliance of principles of natural justice, will it become fatal to the case? This is the subject that was decided. The answer is very clear. They have said this is only a preliminary inquiry. That is, when you are making a complaint to the court that there is something fabrication, falsification. Anybody can file. Remember, not the aggrieved party alone. Anyone else can file false statement. And it is not an inquiry per se coming under the purview of Section 238 of the code, but it's only some opinion they are expressing. It is not necessary that is binding on the magistrate, jurisdictional magistrate. He will have to follow his own process. And therefore, such thing doesn't require. The logic also of the Honorable Supreme Court is, if you are going to again, it will be rehearing of the case will become everything. So it is the court which is offended because you submitted, misled the court. And it is for the court to come to a prima facie opinion. And then it is not just like that they're going to come to a decision. Not only the case is made out, but then the next test will be the expedience in the interest of justice. So even though they find, that's what Dr. Jayachandran's case we have seen. So this is the entire case. So whether principles of natural justice is mandatorily to be followed. Now another question arises. This is a case where the referral court did not hear the affected party. Therefore, the case went up to Supreme Court. But suppose if the referral court believes that there is a need for them and then tells them what will happen, discretionary jurisdiction. That also is made very clear by the Honorable Supreme Court, which clearly says in their latest judgment, Jaspir Singh v. State of Punjab, 3-judge bench judgment delivered by Sanjay Kishan Kaul Justice, Justice Abhayoka and others. 3. They said no, it is not required. Now there is another judgment which has come that any court coming to a decision, calling the people and then hearing them without framing the opinion, without going to records is illegal. So therefore, it is once for all the matter is settled. The respondents does not have any right to be heard. And in the event that court takes that becomes illegal order. Right. This is the another ratio which is settled today. Right from 2001 judgment delivered by Justice Thomas and then 2022 delivered by State of Punjab. 2020 it is written, but the order dated is latest dated. We'll see that one. The important points is that you see in this paragraph, an area of 3.9 acres of land was acquired by the state government for construction of a canal under Arunavati projects 1985. The land acquisition officer awarded a total of 24,000 rupees compensation. It is in, you see it is in 1985 as compensation for the entire land. As the owners were not satisfied with the said award, they moved for a reference under Section 18 of the Land Acquisition Act. The reference court, which is a civil court, on the basis of evidence adduced by the parties, made a big leap by enhancing the compensation amount from rupees 24,000 to 10 lakhs, 30,000. Besides, the other benefits such as solatium, the additional compensation and interest as provided in Section 23 of the Land Acquisition Act. The reference court passed an award granting the said enhancement on 23/4/93. The appellant was one of the beneficiaries of the said award, and the enhancement was made on the basis of evidence adduced by the parties, including the appellant. Though the claimants expressed dissatisfaction even with such an enhancement and moved the High Court for further enhancement, the High Court dismissed the appeal filed by them. So these are the facts of the case where they have undue benefit. In 95, some persons of the locality brought to the notice of the reference court that the claimants had wrangled a whopping enhancement after paying a small amount, playing fraud on the court by producing forged copies of sale deeds for supporting their claim for enhancement. The documents marked by the reference court were fabricated copies of sale deeds in which the extent of land sold had been shown as far less than the real area transferred as per the instrument of sales according to those persons. So the reference court conducted an inquiry. So if you see, who are the persons filed the case? it appears they are not. Some of them, many of them are not interested parties. That is, affected parties, to the sense that locus standi issue, here it is settled. Anybody can file when there is an offense made against the court. That is the one. Then the reference court did that. Yes. Right. Now, we'll take up this. So the reference court conducted an inquiry on being told that the applicants, that the above documents were forged. So that is the first law. The court got down to the relevant records from the sub-registry for the purpose of examining the correctness of the aforesaid 3 documents and found that they were fabricated copies of the original LP. The said court further found that the appellant and one Mr. Rajkumar have committed offences affecting the administration of justice by using forged documents, and the court then passed the following order. It is expedient in the ends of justice on my part to file the complaint in writing against them before the judicial magistrate of the first class, having jurisdiction to take appropriate and proper criminal action against them, as it appears that they have not only cheated the public at large and government, but have misguided or tried to misguide my learned predecessor by preparing and producing false documentary evidence, as well as by giving false oral evidence, just to have a wrongful gain. So here 2 things, documentary evidence and false oral evidence, these 2 things. So it is not necessary you should give, both should be satisfied. Even oral evidence which is false is right. Even the false documentary evidence, both will attract that. So the 341 is the challenge. The 340 they have taken, they went to the advantage and they went to the High Court. The raising the main contention, if you see, the main contention raised before the High Court was that the reference court overlooked the basic principles of natural justice and proceeded to make an inquiry without giving an opportunity to him to be heard in the matter, and hence great prejudice has been caused to him, as he had been deprived of the opportunity to be heard. The learned single judge of the High Court, while propelling the above contention, observed. This is the important observation. The procedure does not contemplate that before initiating preliminary inquiry, the court ought to give notice to the person against whom it may make a complaint on completion of preliminary inquiry, and obviously so, because what is contemplated is only a preliminary inquiry, and if the court chooses to take action against the said person, it does not mean that he will not have full and adequate opportunity under 341B of the Criminal Procedure Code. Therefore, the contention of the learned counsel for the appellants that the court, before initiating any inquiry into the matter, ought to have given notice to the appellants, and that the appellants have a right to be heard, cannot be accepted. So this is the laid down law. Then they all tried and all, and this chapter 26 of these things which affects the administration of justice offences, among the 12 sections subsumed therein, we need to consider only 3. 340 consists of 4 subsections, of which only the first subsection is relevant for the purpose of this case. Hence the said subsection is extracted below. So this is the section 340 subsection 1, which we have already dealt with. So all these things are important. Record a finding to that effect. Make a complaint thereof in writing. Send it to the magistrate of the first class having jurisdiction, the others. The reading of the subsection makes it clear that the hub of this provision is formation of an opinion by the court, before which the proceedings were to be held. You please see, this is a very one peculiar case where the fabrication was done at one point, and then they went to the High Court on an appeal. And in the High Court, the issue judge adjudicated was natural justice was not given. They have not filed it. Take a situation in the judgment of Honorable SMJ delivered recently, where that fellow made a false statement before a revenue authority, which attracted 195(1)(a). Then he came to a writ court. Then again he made a false statement. 191, 195(1)(b) attracts. So now it is for the complainant or anybody to file a case before High Court. This is not an appeal against under 341. You understand that differentiation you must note. Appeal under 341 should always be made to a superior court or the court above the referral court. So many times, suppose you have made an appeal. I made a statement and the same was dismissed by the court number 1. Then you went to appeal against that order, mentioning this is the false statements they made, all these things. And the other side defends that this is not false statement, or somehow they convince that court. That means they are making false statements, fabrication of evidence there again. So again they are saying, yes, we have done correctly, we did this, that, and that means you are making another thing. So you can file before that next court too. It will be better, because suppose court 1 decides against the complainant. Court 2 also upholds the judgment of the first court. So both courts are against the complainant. So it would be better to go to the court 2, because the court 2 decision will be more superior, because the court 1 cannot decide now. The new judge cannot decide what was decided by court 2 is wrong, because it's an appellate court, hierarchical system. Therefore, you will have to go to that court. Right. See the beautiful paragraph this is. In order to form such opinion, the court is empowered to hold a preliminary inquiry. It is not preemptory that such preliminary inquiry should be held. Even without such preliminary inquiry, the court can form such an opinion when it appears to the court that an offense has been committed in relation to the proceedings in that court. It is important to notice that even when the court forms such an opinion, it is not mandatory that the court should make a complaint. See discretionary jurisdiction, very important. The subsection has conferred a power on the court to do so. It does not mean that the court should, as a matter of course, make a complaint. You understand? The law is not mandatory. But if the court believes, then the court should make a finding to the effect that the fact, on the fact situation, it is expedient in the interest of justice that the offense should further be probed into. If the court finds necessary to conduct a preliminary inquiry to reach such finding, is always open to the court to do so. Though the absence of any such preliminary inquiry would not vitiate the finding. So it is not, you have to support it by, we have done inquiry, then we found not necessarily. Court can come to the decision independently based on the facts of the situation. That is one more point. It should again be remembered that the preliminary inquiry contemplated in the subsection is not finding whether any particular person is guilty or not. Far from that, the purpose of inquiry, even if the court opts to conduct it, is only to decide whether it is expedient in the interest of justice to inquire into the offense which appears to have been committed. So that here, when you are a lawyer for counsel for the complainant, you will be stuck up here. Then how to explain this? I request you to read my videos 1, 2, 3, 4 videos I have done. And also the 2 judgments of the Honorable Madras High Court, very informative. SM Subramaniam J and then Dr. Jayachandran J. How they have distinguished. One is yes, another is no. So how they come to conclusion in the public interest, in the interest of expedient, in the interest of justice. Yes. The inquiry defined under 2G of the code is as every inquiry other than a trial conducted under code by a magistrate or the court refers to pre-trial inquiry. And in the present context, it means an inquiry to be conducted by the magistrate. Once the court which forms an opinion, whether it is after conducting the preliminary inquiry or not, it is expedient in the interest of justice that an inquiry should be made in any offence. The said court has to make a complaint in writing to the magistrates of first class concern. As the offences involved are falling within the purview of warrant case of the court, the magistrate concerned has to follow the procedure prescribed under this is 21 of the code chapter. In this context, we may point out that section 343 of the code specifies that the magistrate to whom the complaint is made under 340 shall proceed to deal with the case as if it were instituted on a police report. That being the position, the magistrate on receiving the complaint shall proceed under section 238 to 243 of the code. That we all know that step by step the magistrate shall first he will satisfy himself that copies of all the relevant documents have been supplied to the accused, all that you know. Now, now the question is how this court has been discussing this, the natural justice issue. That is the main issue, substantial law that will have to be decided by the Honorable Supreme Court. Question of law is whether the opportunity of being should be given or not. So, here, the code confers power on the party on whose application the court has decided or not decided to make a complaint, as well as the party against whom it is decided to make such complaint, to file an appeal to the court to which the former court is subordinate, right? But the mere fact that such an appeal is provided, it is not premise for concluding that the court is under legal obligation to afford an opportunity to be heard prior to making the complaint. There are other provisions in the code for reaching the conclusions whether a person should be arraigned as accused in criminal proceedings or not. But in most of these proceedings, there is no legal obligation cast on the court or the authorities concerned to afford an opportunity of hearing to the would-be accused. In any event, appellant has already availed the opportunity of the provisions of 341 code by filing an appeal before the High Court as stated earlier. Once the prosecution proceedings commence, the person against whom accusation is made has a legal right to be heard. Such legal protection is incorporated in the scheme of the court. Principles of natural justice would not be hampered by not hearing the person concerned at the stage of deciding whether such person should be proceeded against or not. So, the Sheriff, M.S. Sharif and another was the state of Madras. A constitutional bench of this court cautioned that no expression on the guilt or innocence of the person should be made by the court while passing an order under the part. An exercise of the court at that stage is not for finding whether any offense was committed and or who committed the same. The scope is confined to see whether the court then decide on the materials available that the matter requires inquiry by a criminal court. In this Nimmagadala case is there, Nimmakayala case, Andhra Pradesh High Court took a different view that has been overruled by the Justice Thomas bench of Honorable Supreme Court. So we are unable to agree. This is the conclusion. The learned single judge in that Andhra Pradesh High Court, as the same was taken under impression that decision to order inquiry into the offence itself would prima facie amount to holding him, if not guilty, very near to a finding of his guilt. We have pointed out earlier that the purpose of conducting preliminary inquiry is not for the purpose of at all. The would-be accused is not necessary for the court to decide the question of expediency and the interest of justice that an inquiry should be held. We have come across the decisions of some other high courts which held the view that persons against whom proceedings should have no such right to participate in the preliminary inquiry. Muthuswamy was a special police establishment. We therefore agree with the impugned judgment that the appellant cannot complain that he was not heard during the preliminary conducted by the reference court and the 340 in the court. Right. That's all, dear friends. And now let's proceed to, this is the judgment. The sum and substance of the case is very clear. This is decided by the constitutional bench recently and confirming this judgment that the accused should not be heard. And as for the reasons explained very clearly that